Hi everyone and welcome back. In today's video, we're going to walk through a landmark paper by Samir, Chopra and Laurence White, published in 2010, Artificial Agents and the Contracting Problem, a Solution via an Agency Analysis. This paper tackles one deceptively simple question: when a bot signs a contract, who's actually bound by it? And why the answer might already exist in centuries-old agency law. Disclaimer: this video is not legal advice. It is produced strictly for research and educational purposes only. For any specific legal issues, please consult a qualified legal professional. Chopra and White open with a striking observation. In the electronic networked marketplace, rarely is a contract concluded on the internet without the deployment of some sort of electronic intermediary. Dynamic pricing bots on shopping websites, proxy bidding agents on eBay, high-frequency trading algorithms on Wall Street. All of these systems determine contract terms, negotiate, and finalize deals on behalf of humans. The artificial agent is no longer an exception. It is the default intermediary in modern commerce. But not all artificial agents are created equal. The paper maps them across a spectrum of autonomy. At one end, you have rule-bound calculators, shopping cart systems that apply fixed rules, easily handled by existing law as simple communication tools. In the middle, there are agents exercising heuristic discretion, like credit risk assessors that weigh multiple factors through statistical models. And at the far end, you have learning algorithms that evolve their own decision rules based on training data. It's precisely at this high autonomy end where the legal fiction of mere tool of communication starts to break down. So, what exactly breaks? Chopra and White examine the four traditional requirements for a valid contract: two parties, consensus ad idem, intention to create legal relations, and consideration. The critical structural failure lies in the second pillar, consensus, or the meeting of the minds. When a human principal has no awareness of the specific contract terms that their bot is dynamically generating in real time, how can we possibly say there was a meeting of the minds? This is what the paper calls the contracting problem. The paper then tests three existing solutions and rejects each one. First, the closed systems approach, relying on master agreements or terms and conditions. But the enforceability of browse-wrap contracts is itself contested, and when the bot dynamically adjusts terms for individual users, the same doctrinal gap reappears. Second, the unilateral offer doctrine, treating the bot like a parking ticket machine. But shopping bots don't present fixed terms. They adjust conditions in real time based on geography, shipping, and user data. Third, the objective intention theory, inferring the principal's intent through a reasonable observer standard. But this commits a category mistake. It tries to locate a human intention that simply does not exist in high-speed automated trading. When we place these three approaches alongside the two agency law solutions and evaluate them against doctrinal rigor, fairness to third parties, and adaptability to machine learning, the only approach that passes all three tests is the agent without legal personality model. This is the optimal incremental solution in Chopra and White's view. And the core insight is this: we don't need to invent new law. We don't need to grant robots human rights. Instead, we treat the bot the same way we treat a human broker, applying the traditional doctrines of actual authority and apparent authority from agency law. The authors abandon the impossible search for a direct link between the bot's actions and the human principal's specific intention. Instead, the authors legally attribute the contract to the principal through established agency principles. So, how do we translate the concept of authority into the world of algorithms? For actual authority, the human world equivalent is an employment contract. For a bot, it's the programmed instructions, parameters, and mandated code rules, the boundaries to which the principal has expressly assented. For apparent authority, think of a boss letting an employee deal with clients. For a bot, it's the principal providing the bot with a public interface to negotiate with users. That act alone creates the basis for apparent authority. This elegantly dispenses with any need for the bot itself to consent. The paper then introduces a taxonomy of three types of algorithmic error. First, specification errors. The human operator writes the wrong rules. The agent applies them perfectly, but the parameters were flawed from the start. Second, Induction errors. A learning agent derives incorrect rules from historical data and enters into contracts the principal would actually object to. Third, malfunctions. Pure system failures from hardware crashes or software bugs. Each of these error types produces fundamentally different risk allocation outcomes. The first, transaction topology. Think Amazon. The operator is the principal, the agent is the backend database algorithm, and the third party is the human consumer browsing the site. In this structure, the operator exercises comprehensive control over the agent's design, code, and deployment. Under agency law, the risks of specification and induction errors naturally fall on the operator, the party best positioned to prevent them. The second, topology, flips the structure. Think eBay proxy bidding. The user is the principal, the algorithm hosted on the operator's platform is the agent, and the opposing seller is the third party. Here is where the doctrinal failure of the mere tool approach becomes glaring. Under that approach, the user would bear liability for all errors, including platform malfunctions completely beyond their control. Agency law, by contrast, allocates malfunction risk away from the user and toward the party that actually controls the system. Chopra and White also provide an economic justification through the least cost avoider principle. Who is best positioned to prevent the error at the lowest cost? When the operator is the principal, specification and induction errors fall on the operator. For malfunctions, the third party, who can recognize an obviously erroneous price, is the least cost avoider. When the user is the principal, specification errors fall on the user, but induction errors fall on the operator, who controls the platform, and malfunctions again on the third party. Agency law naturally distributes risk to the least cost avoider. To the authors, the mere tool doctrine fails this economic test. The paper also critically reviews existing legislation. The UN Electronic Communications Convention and the UNCITRAL model law attribute messages to the originator, which they define by reference to programming, but this misattributes user-operated bots to platform operators. The US USIDA and eSign rely on the mere tool doctrine, binding users to every act of their chosen agent regardless of autonomous malfunction. Australia's Electronic Transactions Act, however, recognizes binding force only where the message was sent under the authority of the purported originator, quietly opening the door to agency analysis. The paper identifies this as the most doctrinally sound approach. To the counterargument that bots cannot be agents because they lack legal personhood, the paper offers a powerful historical precedent. In ancient Rome, slaves were not legal persons under the ius civil. They could not sue in their own name. Yet they possessed the legal capacity to enter into binding commercial contracts on behalf of their masters, based on expertise and reliability. Similarly, modern minors lack full contractual capacity, but can still bind their parents or guardians. Full contractual capacity in one's own right, the paper concludes, is not a historical prerequisite for acting as a legal agent. Let's bring it all together. By treating artificial agents as legal agents without legal personality, the authors try to achieve two things simultaneously. First, a doctrinal fix. They abandon the fiction of the mere tool and the impossible search for a human principle's specific intention. Second, an economic fix. Consistent alignment with the least cost avoider principle, protecting innocent third parties and users from autonomous malfunctions. Chopra and White conclude that this is a structurally sound, scalable legal architecture for the future of autonomous commerce. And that wraps up today's video. Thank you so much for watching. If you have any questions or thoughts on this paper, please leave them in the comments below. If you found this video helpful, don't forget to hit the like button and subscribe to the channel. I'll see you in the next one. Take care.